Rule 1.17 pertains to the sale of a law practice. Rule 1.17 was adopted by the American Bar Association at its Los Angeles mid-year meeting in 1991. Since that time, one state after another has adopted Model Rule 1.17. To my recollection, at this stage, only 4 states still specifically prohibit the sale of a law practice. Since 1991, the American Bar Association caused the creation of a Commission on Ethics to review all of its model rules. And during that process, I was a catalyst, I'm proud to say, for causing the Commission to review 1.17 and adopt a modification. The modification enables a practitioner now to sell not only the entire practice, but also a practice area. And that came about as a result of an engagement that I had with 2 lawyers who were in their mid-70s, who wanted to sell their practice. They had an estate planning practice and a probate and trust administration practice. They wanted to sell the estate planning practice and attain the goodwill from that practice area, but keep the probate and trust administration segment. The reason for that was obvious in that the estate planning practice requires marketing and administrative work and so forth that they no longer wanted to do. The probate and trust administration practice required no marketing. They had hundreds of wills in their vault. So when the heirs and family members of a decedent went to look at the will and saw the name of the lawyer in that will, they would call generally the law firm. And so that's a great marketing tool, and maybe 50% of their clients would call them, whatever the percentage was, but it was a high percentage. Why didn't they sell the entire practice? Well, in their mid-70s, they had become accustomed to going to their office. For 50 years, they were engaged in the practice of law and actively doing so, feeling as though they were making a contribution not only to the well-being of the society, but more particularly the well-being of their individual clients. Furthermore, having had the pattern of going to their office for 50 years, their wives were accustomed to them being away for a good chunk of the day. And they specifically told their husbands, don't stay home or you'll be killed. Now, I know that that's an exaggeration, but the fact is, as all of us can understand, when we change a pattern of conduct that we've been in for so many years, sometimes the conflict that's created in the family becomes more than what we really want to deal with. Anyway, needless to say, they were encouraged to continue to practice. As a result of the then current state of the rule, they could not sell only a portion of the practice. They had to sell their entire practice or could not sell any of it. Choosing to continue to practice in the administration, probate and trust administration area, they closed down their estate planning practice area, did not sell it, and lost the value of that practice just by closing it up. That, I think, is a crime. And I brought that to the attention of the ABA, and the ABA House of Delegates ultimately agreed with my position. So that's where we are today. Now, the issue that I want to raise with respect to 1.17 is one that occurred just in the last several days that came to my attention. And it came to my attention because of a conference that I will chair, and by the time you see this tape, I will have chaired it already, in Chicago, presented by West, the Midwest Law Firm Management Conference, to be held at the offices of the Chicago Bar Association. And one of the panels on that program will be on succession planning. And as our panelists and I were talking, Rule 1.17 came up for discussion. One of the assertions by one of the managing partners on the panel was that Rule 1.17, at least as it's interpreted in Illinois, is an inhibitor to good succession planning because there's no transition permitted in the rule. In other words, when you sell the practice and you go through the 90-day notice period to clients and the escrow for the sale of the practice closes, the deal is done and the lawyer can no longer practice law. There is no provision there for a transition, for the selling lawyer to help the buying lawyer transition the relationships between him, the seller, and the buyer to help assure the buyer that the buyer is getting what the buyer bargained for, that is, the continuing relationships with the existing clientele. I maintain that a transition is permitted under the rule. It does not specifically say so, but I think the language is such that it can be interpreted that way. When the transition is by the selling lawyer with the buying lawyer. Usually, the selling lawyer is an older lawyer, somebody who's been in business for quite some time, and he's not looking to make a killing today and open up another office across the street tomorrow, or a year from today, or 3 years from today. The lawyer really wants to get out of the practice of law and is interested in helping the buyer in a transition for a period of time. That may be 6 months, it may be a year, whatever it is that the buyer wants to request of the seller. So this, in my mind, now is a question that I had never really considered before. I think that there's room for discussion and disagreement, but I think that this is an issue that needs to be addressed when you're dealing with the sale of the practice of law. Think about what kind of transition you want from the seller. Think about what kind of agreement provisions you want to have with respect to a covenant not to compete. What we're talking about is a retirement issue. And in that context, I think 1.17 can be read broadly enough to permit the buying lawyer to ensure that he will get what he's bargained for by having the selling lawyer stay with that person for a sufficient period of time to assure the transition of client relationships. As I said, it's an interesting issue. It's one that has not yet been litigated to my knowledge, and one that we have to be careful about in future deliberations. Thanks for joining us today.